Hello and welcome to another episode of A Question of Law. This is CTTV's legal education program, and we seek basically to, break down the issues as concerning our daily lives and daily activities. What does the law say regarding all of this? This is what the show is about. We do want to hear from you at any point in time throughout the show. If you have any questions you have for us, well, the hashtag is A Question of Law and the WhatsApp line is 0550585832. We do want to hear from you here on this show, so please do send in those messages. I'll take a short break, come back, introduce my guest to you, and we'll have a conversation. Welcome back. Now, it appears that the last few days have been quite a bit of a legal fest. Now, my guests are seated. Salam Adonu, who is a private legal practitioner, as well as Clement Kojo Akuapem, who is also a private legal practitioner, as well as a senior law lecturer at the Law Faculty of Gimpa. Hello, gentlemen. You're welcome.
Hi, Kweku.
Yes. So like I said, it appears that we've had quite a bit as we approach the festive season of Christmas. We've had quite a bit of a legal fest in the last few days.
I think that we are being served a buffet of legal issues.
Yes.
There's Sosu on the table.
Yes.
Bench warrant has been issued.
Yes.
Now it's the court asking that he be arrested and brought to court. So the matters have heightened.
Yeah.
And I think that at this point, we were hoping in previous discussions that it wouldn't get to this point.
Yeah.
And I was saying that if the member avails himself, then there will be room for such discussions to be had. But at this point, it appears that, yes, all the ketsis will not be granted because now it's an express order of the court.
Okay.
And the police must follow the express orders of the court to bring him. So let's see how that pans out. I mean, alternatively, he's also started an action at the Human Rights Court. But those are two different things.
They don't impact on each other?
They don't impact on each other from my learning. I don't think that it has any direct impact on the criminal process.
Yeah. And Akuapem Poloo was also being...
Yes, but before that, what I think, just to add to this, is that the constitutional provisions about, what should happen to or should not happen to a member of parliament when he's attending at or returning from Parliament.
Yes.
I should think those ones will still be in place. If he's on his way to Parliament, you cannot serve him or say he's warrant, I'm arresting you.
Right.
Otherwise, would have gone back to the reason why this provision was put there. Like Clement pointed out last time about the king of England wanting to control Parliament, etc.
Yeah.
So that provision in the common law was brought. So to the extent that he is going to Parliament, attending at Parliament or returning from Parliament, I think he still enjoys that immunity of it. I recall before the crucial vote, of Tuesday occurred. I think that was the day. Was it the day before the warrant was issued? And people were saying that he could be arrested. It was the reason why arrest has been issued, warrants have been issued, etc. People even said that then he should sleep in Parliament. I don't know what he did, whether he slept in Parliament or not. But if by the strict interpretation of the law, you could not have arrested him on his way to Parliament while attending at Parliament or on his way from Parliament. Even though, given the nature of the situation, an attempt could be made, and so by the time you would end up adjudicating, say it was wrong for you to have arrested him here, etc. Maybe the crucial thing or the reason why maybe he should have been in Parliament would have gone, would have passed. Yes, but basically that is it. Yes, and
talk about Akuapem Poloo
as well. So if you recall, Akuapem Poloo earlier in the year found herself, at the wrong side of the law. There was a picture the year before she took with her son. I think the son's 7th birthday or so, where she was, I think, nude with the son and took a picture, and she claimed she wanted a child to see where he came from, appreciate humanity, women, and be careful. Appreciate women and treat women well, etc. Some wild, rationalization of that. there was a complaint made by, I think, the Child Rights International.
Yes, Child Rights
and the matter was taken up by the police, and the matter was prosecuted. They went to court. I think initially she pleaded not guilty. I don't know what they saw in the prosecution's brief. I don't know what her lawyer saw. At a later court sitting, she was advised to plead guilty, I think, or she pleaded guilty. And once you plead guilty, the next thing for the judge to do is to convict and go ahead to sentence you.
Okay.
Right.
You know, so once you are convicted, you have to be sentenced, and that is law. Okay. So now they look at the offenses and see what corresponding punishments or sanctions come with those offenses. Yeah. Exactly what the judge did. And there was this whole talk about she should have been forgiven, etc., etc. And the judge or the magistrate, I think the secretary, the judge was clear that it was to be punitive, so it will serve as a deterrent to herself and to many others, because given her position as a celebrity, whatever the definition for that is, she obviously is a popular person. Yes. And so once you are popular, you have a following. And once you have a following, a lot of people adore you, they idolize you. What you do sometimes becomes the trend. So I wouldn't have been surprised if this wasn't punished. Later you see people doing similar things, and that would not be appropriate. So the court felt that she had to serve a custodial sentence, give her 90 days for the 3 charges, and they were all to run concurrently. The judge could have been stiffer, or could have decided to go, harsh on her, but gave her 60 days. The judge could have also decided to fine her. Okay. They appealed, a whole lot of people came in, they appealed, and the appeal was heard, and the appeal is being refused, which means that she will go continue from where she left off, because she has said a few days. Okay. So now she will go back and continue from where she left off. Okay. That is what the law is. And indeed, the judge who sat on the matter said she did not think that the punishment was harsh, and that it was important that she is punished to serve the purpose for the law. So basically, that is where we are. I think everybody should be aware, especially in this new damparic environment we find ourselves in. So that is what it is. I don't know what options. Of course, there are options available to the lawyer. They can decide to appeal again. Okay. Maybe go to the Supreme Court or something. I don't know what options are available to them. Okay. I don't know what advice the lawyer will give them. I mean,
I think the biggest of the stories so far is the issue of 2022 budget, the constitutionality of where it is that we find ourselves. At one time, there was a rejection, then there was an overturning of the rejection.
Purported?
Well, yes, okay. Yes, purported rejection and overturning of that same thing, and subsequent approval of same, and we find ourselves here now. But I want to take a look at this insert right now. We'll do that, and then we'll come back and delve into the conversation.
Those in favor of the approval of motion number 11 on the order paper, who says, and I read, that this Honorable House approves the budget statement and economic policy of the government for the year ending 31st December 2022. Those in favor of the motion say aye. Those against the motion say no. Honorable members, clearly the noes have it. The motion is accordingly lost.
Honourable members, for the avoidance of doubt, let me read out the constitutional requirement so that there is no confusion as to who can vote, what numbers are required to take a decision. Article 104(1). except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting. The vote of the majority of members present and voting, with at least half of all the members of Parliament present. What it means is that before you take a decision, there must be at least a majority of all members present. With me, we have 138 members. That's a majority. It doesn't mean that all the 138 must vote yes or no. A majority of this 138, their decision will carry the day. So, I'll go ahead and put the question on the motion proposed before us. All in favor of the motion, say aye. Order. The consequence, though, of the unfortunate error is that the putting of the question of the budget statement and the question on the budget statement and the economic policy was done in violation of Article 104(1) of the 1992 Constitution, and therefore void and inconsequential, as the record shows 137 members were in the chamber. Now, members, the motion that was moved by the Honourable Minister and have been debated is now ready for a decision to be taken. We have already determined that the appropriate numbers are in the chamber, and therefore the House stands ready to take a decision. Now I'll put the question. I'll put the question. All in favor of the House adopting the resolution moved by the Honourable Minister for Finance, say aye. Aye. All against, say no. The ayes have it. The motion moves. The House has adopted the financial. The House has accordingly approved the budget statement for the ensuing year ending 31st December 2022.
Welcome back. So now I guess the first question is, let's go back to the beginning of this. What instigated the initial purported rejection of the budget? Take us into.
Okay, I think some context before Clement comes in. Yeah. So the budget is it's a constitutional requirement. Before you spend, Parliament must approve the expenditure, appropriate constitutional provisions for that 174 to 179 or so of the Constitution deals with that. So a minister, on behalf of the President, must present to Parliament its financial policy and budget, and the representatives of the people must look at it, debate it, and pass or reject it. Okay. What has happened in the previous past, overwhelmingly, is that it's been approved. However, on this count, the representatives of the people, some of them, felt that some of the policy proposals or propositions in this particular document, maybe were too harsh or were not appropriate. And so they said some of them, some things should be done to them, review, change, etc. And if those things were not done, they were going to go ahead and vote against it. And interestingly, the group of MPs or representatives of the people who felt that those things like the e-levy being too high, there was something about Aka energy, there was
the Ejapa deal.
There was a number of things. If those things were the group of people who felt that those things should be relooked at, incidentally, were members of the minority, mainly the NDC group. On the other hand, the majority group, as the MPP plus the independent candidate, felt otherwise. So now it came to a head. Parties were not maybe, there were no fruitful conversations in respect of what the difficulty, the difficult points in the budgets were. So they had to go to Parliament, they had to debate, they did the debates, etc. The conclusion of the debate would then be the approval or otherwise of the budget. And so that happened, we saw that last Friday. So at that event, the Speaker of Parliament presiding, both sides heavily represented, even though we had one or two, or maybe just one or two of them were not available, the MPs. And so now it became a question of numbers. We haven't really been here in the Fourth Republic because, we've always had good majority.
On one side,
so, but in this case, we have 137 apiece with one independent candidate in between. And so it meant that, you have to, proceed cautiously because by one or two, you could lose a major vote or you could lose a major decision. And so the minority, knowing that, also came in very hard. And indeed, they used the same approach to get the speaker on their side the night of 6 into 7 January when the speaker was elected. They used their numbers, got one or two people from the other side to join them, and then they won the speakership. So the speaker became the Speaker of Parliament, but one sponsored or proposed by the NDC group in Parliament. So we found ourselves in a situation where it came to a vote. Finance Minister was there praying to be allowed some time to caucus or interact with leadership of both sides. That prayer eventually was put to a voice vote. There was the call for division, and in that process, we saw a walkout. For whatever reason, whether Stephen Kita was there, and that was the reason, or whether because the speaker asked non-voting or non-MP ministers to move out, etc. Whatever the case, there was a walkout. And so after the walkout, the question was put nonetheless, and that was a decision. And so the noes had it in respect of the motion, whether the finance minister should be given time to interact with the two sides of the House. So that motion was lost. Now to the substantive reason why they were there.
Before you get to the call for, before you get to the substantive issue, you said there was a call for division. If you can just sort of explain what that, what that.
No. So a division is, as practice here, will be a head count of a sort.
Okay.
But in the Westminster Parliament, a division, when a division is called, actually there will be two doors where one will be marked the no and the yes, and you will walk through. And as you're walking through, you'll be counted. But we have modified that process. Once a division is called here in our Parliament, what is done by way of parliamentary practice will be that there will be a head count of members present. So that is...
So who does that? Is that clerks of Parliament?
So the clerks will do the counting.
So
those are the table officers.
The call will be made, and then the clerks will do that. And the division in this case became necessary because of the equal numbers. So if people screamed or shouted, that yay or here, or and the other one shouted nay or no, because of the numbers, the parity of numbers, it's difficult to tell the difference. So even though the speaker pronounced that the noes had it, it was challenged that no, we don't think so. So let's put it to a division. And so that was going to make them see exactly how many people were in support or in opposition to that particular motion. So there was a walkout. Eventually, the substantive question was put about the approval or otherwise of the budget. And we had a result we had. One side said it was unconstitutional because of we didn't have the numbers for decision making at the time. The other said no, it's not. We came in for this reason, for decision making. This is the attendance in Parliament, and so it is right. Tuesday, now the matter was adjourned. Speaker travels out of the country. Tuesday comes, and now somebody else had to sit in Speaker's seat. First Deputy Speaker by law will have to take that seat. Our First Deputy Speaker is an MP. Question is, does he retain his status as MP
representative of the people
whilst presiding, or once he presides, he loses, the the MPship in a sense. So legal arguments and even political arguments have been proffered in respect of that. So basically, that is where we are. So I think we can begin the legal arguments.
Yeah, I think that Salom has done a good job setting the news and political context.
Yeah. Clement, as a layperson,
yes.
Okay, to me, you are representing people in Bekwai. You sit in a different seat with different responsibilities. Do you no longer represent those people in Bekwai? That's for me as a layperson.
Let's take it.
Take us into that.
We should just understand that Parliament must be composed by a certain number, and that number is fixed by the Constitution. So the Constitution will tell us that in the minimum, 140. Over the years, we've had the numbers increased, 200, 230, 275. We have currently, the 275. Now, the problem we are facing is also a problem caused by the way we have increased these numbers. Because there are requirements in the Constitution that certain decisions you need 1/3, certain decisions you need half. So it means that when we are increasing, we should have these fractions in mind. Because currently the issue is 275. If you divide it into 2,
it's 137.55.
Yeah. The argument is, are we rounding up or are we rounding down? If you round up, you are creating a half human being. If you round down, you are denying the existence of so you see that
human being.
that increase to 175, we should have been more organic about the increase and look at these divisions. And that's something that we don't do in this country when we are making laws. It is the power to demarcate constituencies is given to the Electoral Commissioner. But I think that increasingly, this Parliament is giving us a lot of things that we will need to change by way of our Constitution and even our governance structure and even how we make laws. So the EC in demarcating constituencies must have this in mind. If we don't, we will have this problem where you cannot get a clear half and their fractions. That being said, Article 93, David, this matter, it says, there shall be a Parliament of Ghana which shall consist of not less than 140 elected members. If you read 93, the Speaker is not a member of Parliament. So when we are counting members of Parliament,
don't add him to the
we
number.
don't add it. So I've read 93 to you. Let me take you to 96. 96 says, there shall be 2 deputy speakers of Parliament. A, who shall be elected by the members of Parliament from among members of Parliament. Meaning that the deputy speaker is a member of Parliament first before he/she will be qualified to be elected
as deputy.
Now, this election, that member who has been put up as a deputy speaker can vote in that election. Do you know that? So I can, if let's say I am MP for Bulsa North, I'm not taking my MP's position.
and that's the thing, must not be considered like.
If I am an MP for a certain constituency, and I've been put up for election to deputy speaker, in that election for deputy speaker, I have a vote. I can vote. So the question of whether a deputy speaker can vote or not depends. If it is during his election, he has a vote. Now,
but if it's during his election, then he wouldn't have become deputy speaker yet.
Yes, but he's voting because he's a member of Parliament. What gives him the vote is because he's a member of parliament. Now, when he is elevated
to
the post of deputy speaker, it does not take away his membership, because actually if you take away his membership, then it means that you are reducing the composition of parliament by 2 members. If you say that their elevation takes away their membership, then our parliament will be composed by not 273 by 2 members less. But that is not the intendment of the framers. So what the framers will do in the light of Constitution 1992 is say that once you preside as deputy speaker, because you are presiding, you do not vote. That matter, I think, we will even need the Supreme Court to look at that issue one of these days. Because it means that when a deputy speaker presides, in the absence of the speaker, the people of his constituency are denied a vote. And I don't think that it should be right. Because at that point, what we have is a member speaker presiding. And that member speaker is wearing 2 hats. A member of parliament
as well as
and a deputy speaker of parliament. So whether the deputy speaker counting himself was right or wrong, I hold the view that yes, he can count himself for the purposes of members of parliament present. And he can then decide that on this matter, I am disabled by legislation to vote. However, I am present. And if you take the votes and proceedings in the House, MP for Bekwai will be marked present. If MP for Bekwai is marked present, then he is present.
Then he is there.
You understand? So for the purposes, and the argument is that we need to delineate being present and voting. Because even the requirement in 104, being present and voting, it is not all who are present who must vote. It is the majority. So you can have 138 present and 100 will vote in favor and 38 will vote against. Still the majority. And in this case, the point is that the deputy speaker must be recognized as a member of parliament. Otherwise, this is what's going to happen. No one in a tight parliament like this will want to put up their members for the deputy speakership. Because what it will do is that it will reduce your strength in parliament. And that is not the intendment of Constitution 1992.
So the question I have, and I think we'll answer this after a short break, right? But the question is, so does he relinquish, in the case of sitting in the seat of the speaker, does he relinquish his first deputy speakership? But don't answer. We're going to go for a short break. Let's go for a short break. We'll be right back, and then we'll hear the answers. All right, welcome back from that break. Now, the question that I asked before we went, what do you think?
That question is addressed in Article 101. It says, the speaker shall preside in parliament in all sittings. And in his absence, a deputy speaker shall preside. So when you are presiding, you are a deputy speaker. You are still a deputy speaker. And a deputy speaker is a member speaker. You understand? And that's what I'm saying, that a member speaker is a member of parliament. When parliament is meeting, when we say we want members of parliament to gather, the 2 deputy speakers will be present. The speaker cannot join that meeting.
This is interesting. So it's spelled out in the Constitution, really.
When there are caucus meetings, minority caucus, majority caucus, the deputy speakers will belong to any of the caucuses.
When Parliament is in session and the speaker is presiding,
Yeah.
the deputy speakers are on the floor
As members.
The MPs,
Okay.
because they are MPs.
as members.
Okay.
So they are members.
Okay.
Their membership is not in doubt.
Okay.
At this point, we are saying that when we elevate you to the status of the referee in the absence of the speaker,
Yeah.
because you belong to a side
Yeah.
on the floor, we are saying that on the question of voting,
you can't.
you
vote.
cannot.
Yeah.
But we cannot say that on the question of you being present as a member, we cannot have that.
Yeah.
And I think that that's a fine line. If we don't do that, I'm saying that if I have 137
Yeah.
and Selom has 137,
Yeah.
and we are looking for deputy speakers, I won't put up any candidate.
Yeah.
I'll actually allow Selom
Yeah.
to put up,
To
because I
have
know
to,
that
'cause it will go
once he
against
does
you.
that,
Yeah.
his strength
Yeah.
is reduced.
Yeah.
So then automatically I will be majority, even though I might be in the minority. But I'll have numbers more than. But that's not the intendment. The intendment is that in the absence of the speaker, you have persons who understand the workings of parliament, who are members of parliament themselves, to preside. And these are meant for temporary situations.
Okay.
It's not for a long
Yes,
absence
yes,
of the
yes,
speaker.
yes, yes.
That there are times where parliament is sitting from 9 in the morning till 9 in the evening, so that you have breaks where another can take over just for to ensure that there's freshness and the debate can be moved properly. So my view is that when it comes to the numbers, member speakers who are deputy speakers are members of parliament, and their position as members will remain. So I didn't even expect the deputy speaker in this case to have said that, oh, the clerks have counted and it is 137, and I, as MP for Bekwai, am 138. I was expecting the clerks to have counted him.
Yes.
No, but I think the clerk's job was to count the
members
on the floor.
No, the members on the floor, and he was on the floor.
No, wait. So they counted the number on the floor.
But
That was
he was on
137.
the floor. That's what I'm saying. You see, it would have been less controversial, and that's what I'm saying, that we need to understand.
Okay.
Because if the clerk, those at the table office, had the impression that he's a member of parliament, so I'm counting members of parliament, then he will say, "Oh no, don't include me." Then we can say, then someone will say, "No, you're a member of parliament."
Okay.
That can be an argument. But the clerks counted those on the floor, 137. Said, "Okay, I am MP for Bekwai, so add me as one."
And see, indeed, if you look at the attendance on the, we didn't even have to go through this to establish the number present at the time. You could just look at the attendance. How many MPs were in Parliament on that day? It's 138. Because Bekwai will come not as Speaker, he would have signed in as MP for Bekwai. And so just by looking at the attendance
You
on
know
that
who's
day,
there.
you know there are 138 in there. And if the number expected in the House for decision making is 138, then by just looking at the attendance sheet for that day, you'd have known whether you are qualified or not.
No. This point that Selom just makes about the attendance sheet. So there are periods in Parliament where the Speaker of Parliament, properly so called, will start the proceedings. So the MP for Bekwai would have marked himself present, MP for Bekwai.
Okay.
Along the line, he takes the seat.
Okay.
When the Speaker vacates for short periods. It does not make him absent.
Okay.
He is still present.
Okay. Yeah.
As a member.
Okay. Right.
So even from that analogy, you can see that the intendment is not to say when you preside, then you are disabled of voting and your membership. Yes, I concede on the point of the voting because you are the referee at that point. But for the purposes of presence, you must be counted. The reason why I will concede on the voting is that you are the referee in the matter. But because Parliament and decision taking is a numbers game, you cannot deny him of his numbers. Because he can be there and decide that he will not even vote. But he is there. Exactly.
But in this case, now it goes to a voice vote, which means that it's a matter of the audibility of, how loud the ayes have it or the nays have it.
Right.
So then if he's silent,
yes,
then he didn't vote.
But that's difficult to tell.
Exactly.
That's
because
how
the voice vote.
And because the numbers at that point were almost
But you
equal.
do realize that even on the TV, as we're watching him, we can hear his voice on camera. So if he voted, we would have heard him.
Who? The speaker?
The deputy speaker.
No,
the first deputy.
No, but he couldn't have voted in that case.
In that case, yes.
All he needed, all we need is the number.
Yes.
To take a decision, you need a certain number,
Kweku.
which we have come to say is
Okay, no, I
1
think I'm referencing the time when they did a voice vote.
Yes.
Part of it.
Yes.
Where you're saying that did he vote or did he not vote?
No, but he didn't have to vote.
Okay.
He didn't have to vote. But that vote was important because it was a decision that had to be taken. And by law, you needed a certain number to qualify the House to take a decision.
Yes,
and that number was
138.
138.
Yes.
So the number present in the House
was 138.
should be 138 MPs.
Okay.
And Bekwa MP is an
Minimum.
MP.
Minimum.
Forget the fact that he's sitting as speaker.
Okay.
So he was present. And so once we scale that, that's it, we can do business. Right. Now we go to decision making.
Yes.
So pronouncing on the motion by the finance minister, whether to engage the two sides or not,
yes.
Pronouncing on that motion becomes a decision.
Right.
And the speaker, deputy speaker now, did not have to vote in that, so he didn't vote.
Yes.
So he only counted himself as being present in the House, and that qualified or allowed the House, or closed the House to do business in terms of decision making.
Okay.
You understand?
Okay.
If that had been ordinary business, like taking statements, etc., the 138 wouldn't have been an issue. That would have been 1/3 of the House. That would have been 1/3 of the House.
That's what you were saying earlier on.
But because it was a decision-making moment, you needed what we have now come to say is 138 in the House to ensure that that decision was binding and properly made.
So, even with the voice votes, even with the voice votes, we could have had, when we had the majority side with 138, when the question was put, you could have had a group of people saying no. Even with the voice vote. And it wouldn't have affected. The speaker also now have to make the judgment whether the ayes have it or the... Exactly. So it's not, we just need the number to be 138 for the purposes of voting.
Okay.
Then when we vote, the majority of those present must vote to carry the day. And that's and that's what happened.
And you see, all these controversy, etc. Once you resolve the issue of the member speaker being a member, that's it. Because once the 138 is present, you can now make decisions. That's it. Once 138 is present, then everything flows from there.
The Supreme Court has been invited to look at this. 2 writs have been filed.
Okay, interesting.
The Supreme Court is being called upon to look at what transpired with the purported rescission. I'll call them purported now because they are both
rejection.
And the purported
rescission of say.
Yes. The Supreme Court will look at it, and once the Supreme Court gives guidance, we'll follow. But even at the Supreme Court, there are hurdles that we might.
Really?
Yes, of course, because there's overwhelming jurisprudence from the Supreme Court itself that says that Parliament must have its own rules. So, and they are not ready to go and inquire into.
We are seeking clarification on the Constitution, and it lies within their bosom to do that.
That's what I'm saying. I mean, let's see what the let's see what the Supreme Court.
What it means is the Supreme Court often, when it comes to matters of Parliament, it's not in a hurry.
Okay.
It will rather hasten slowly. And if there are ways, it can throw it back to Parliament
for
to
them
deal with their own matters.
Right.
So before they agree or before they sit to look at this matter, they will have to think broadly to see what the effect of their pronouncement on it will be, etc. If they find that it will be appropriate for Parliament itself to use its own internal mechanisms to deal with this matter, so be it. And everything that happens on the floor of Parliament also, it becomes precedent. And so there will be enough precedent, maybe at every point in time, to deal with matters. If there is no precedent, a precedent will be formed. And they have a way of dealing with their matters. Supreme Court is not bad from it, but they will hesitate or they'll be careful or a bit cautious in prying into matters of the legislature.
Yeah. No, David, we have interesting times ahead because even calling upon the Supreme Court, I would have thought that an interpretation on whether or not is right to deny the Deputy Speaker a right to vote is constitutional.
Okay.
Because he's there representing
a group of people. Yeah.
So imagine there's a decision and his constituents have an opinion.
Yeah.
And he wants that opinion to be carried.
Yeah.
And for reasons unknown, he's presiding. So his vote is disabled.
Yes.
Is that right?
Yeah.
We are talking about representational democracy.
Yeah.
So we didn't send you to Parliament to be a deputy speaker. That's a post.
Yes.
We sent you there primarily
to
as a member of Parliament to represent us.
I mean, for me, I think that's the way I've seen it the entire time. So it's interesting to hear, this, and then to also know that Supreme Court is going to be looking at this. Yes. This is going to be fascinating.
So I think that the issue of quorum, I've heard the talk about quorum also being a vote. So the fact that the Deputy Speaker counted himself as part of that quorum to allow for the decision-making business of the day to happen, was a decision that he didn't have to vote in because the quorum, per that argument, constituted voting. The quorum necessarily is not voting. The quorum is just a count of the numbers to clothe us with the appropriate authority or power
to vote,
to go ahead with to vote or go ahead with whatever business we have to do. So it could be 1/3 or it could be 1/3, 1/3 or at least half.
Not less than half.
Not less than half. At least half of the house.
Yeah.
So whether quorum is a vote or not, I don't think quorum is a vote. Quorum is quorum, and it is the minimum.
No, but are people arguing that quorum is a vote?
Yes, I've also heard commentary that the quorum, adding himself to the quorum, was a decision, a vote of a kind. I disagree.
No, Kweku, I think that the happenings in recent times are pointing us to even some mathematical deficiencies with this our constitution. I think that, interestingly, I'll be looking for people at the maths department to look at, because you say 50% plus 1.
Yeah.
And this, that we've had arguments from the mathematicians that there's nothing like 50% plus 1.
Yeah.
50% plus a single 1.
Yeah.
No, you see,
but in this case, it's problematic.
No, it is. And we've had situations where you're saying 1/3 for an odd parliament or half for an odd number parliament.
Yeah.
So I think that we need to look at ways of harmonizing these numbers and say that our parliament will always be composed as even.
Yes.
And then when we say half of parliament, this is it.
Yeah.
So then the other authority, clothed with the powers to demarcate and make constituencies, when doing so, will bear this in mind and give us even numbers. But the Constitution pointed us to it.
Yeah.
Hopefully, Guan comes to solve this. So Guan comes and makes it 276. That's if Guan will come alone. Or Guan will come with friends.
Yeah, but then there are those who are also proposing for the capping of the number of members of parliament.
Well, that's for another day.
If
Constitution 1992 said we needed at least 140 for a parliament to be properly constituted. I think that what we have now, and even for the space, and that's why there's clamor for a new chamber for the space. We need to look at it. I am for a capping.
Yeah.
I am not only for a capping of the number of members of parliament. I'm for a capping of the number of ministers and deputy ministers.
Yeah.
I think that we're talking about budgets. We're talking about expenditure. These are huge expenditure points for the government machinery.
Yeah.
So we need to have a discussion on capping these and then rather broaden local government participation and let people at the local government level now participate to bring development at the local level. That's my view of this.
The capping, it sounds like a good idea but practically, that may be problematic because there are laws which say that people in like when the number goes beyond a certain number in a district, maybe a new district must be created or a new constituency must be created, etc. What also happens is that we have a law which says that you cannot have two constituencies or one constituency in two regions. So where we have not capped the creation of regions and districts, we cannot say we are capping the number of constituencies, because you create a region and it could so happen that a district or a constituency will fall in the two regions, unless of course in the creation of the new region we create it such that we go around the constituency, so we will not have a constituency in two regions. So until we do that, it will be difficult to cap it, because maybe a new government may come, or even this government, or people may start agitating from a certain part of the country that we need our own region. A commission of inquiry will be set up to go into it and may find merit in that. And so we will have to put it to a referendum. It so happens that we must create a new region. So, it's because we cannot cap that, I think it will be practically quite difficult to also cap the number of constituencies, even though that would be desirable.
Yeah, but it's in terms of, like Clement mentioned, in terms of the budget, we cannot just keep going forever.
But what we say is that democracy is expensive.
No, but we can't keep going forever.
No, but yes, democracy is expensive. Yes, I'm with you. I'm just looking at what the practical challenges of that would be. I don't want 120 something ministers. Even 80 ministers I don't want. I want the numbers to reduce. I don't want a 275 member chamber. That's too huge for a small country like Ghana. But what are the practical challenges in seeking to enforce or cap the number?
So maybe what we should do is to open up that
the practical challenge
talks about breaking up constituencies.
Exactly. So the practical challenge is that law.
Fix that one.
Is that law?
You see, and
that's what I'm saying,
up.
that we need to fix. And this parliament, for what it's worth, is throwing a lot of things at us. And we need to sit down, devoid of emotions and politics, to see how we smoothing our path moving forward. And one of the things is how constituencies are created, how districts are created, and even how we demarcate our regional boundaries. And if we are taking the decision of capping, then that will percolate into these other areas of how we deal with district creation and how we deal with constituency.
We don't like capping. Even the Supreme Court bent, for example, the arguments in cap. We don't like capping because we don't want restrictions.
No, but you see, we have to be. I don't think, as a people, we need to start thinking not about us today, but about the future, posterity, about Ghana. Because 100 years from now, the population will not be what it is. We may be double what we are. Are we going to say that because of that we're having double number of people in parliament?
Which mean that we could have bigger parliament or more members of parliament to make representation more effective, maybe. Because if you have 500,000 people...
but which country has an unlimited number of people?
If you have 500,000 people...
it doesn't work like that.
Of course, we're just throwing up the issues. I so much agree that we must cap it at some point. But at what point do we do that? And what are the bottlenecks? So do we say that if I have 500,000 people in my constituency, will I be effective as a representative to those people compared to somebody who has just 20,000?
But that's where
and how is the district assembly's common fund disbursed? Is it a formula which takes into consideration the number of people in that district? I think we must look at all those so that we don't give one figure to everybody. That would not be fair.
All right, thank you.
So it's a whole thing that we must do. It's an overhauling of the system, perhaps.
Governance re-engineering.
That's all.
Caused by 137.
Well, we're going to take a short break. Don't go anywhere. A question of law. We'll be right back. All right, welcome back. So what's the way forward with this whole budget 2022?
Well, the way forward, so this is a socio-economic matter, mainly an economic matter that has become legal, because the way to get to the economic meat of it, the procedure must be legal. So it's an economic matter, really. And given the nature of the House and what Haruna said, that what did he say? Is it consultation or consensus will suffer in the House? And we are now getting to the real part of the deal, which is the appropriation. I think cool heads must prevail. both sides must respect each other. Both sides must know that they don't have it
and talk to each other.
And talk to each other.
Yeah.
In any case, they are representing themselves. The mistrust, in my view, is too much. But they must find a way of working together. That's what the people of Ghana have decided.
Yeah.
We want you to go and talk together.
So the leadership have work to do.
And people must find ways of trusting each other and respecting each other.
Okay.
Dropping the ego sometimes and talking, to make it work.
Compromising here.
Yes. So compromise is what must happen.
All right. Let's take a look at the docket for today. Someone I considered a friend and a work colleague came to my house for a visit. And during our interaction, she asked me a question I found very odd. She asked me if I had either gone out with her husband or slept with him. I responded with a firm no, and that was all there really was to this matter. A week after this incident, some of our mutual friends sent me audio messages of this lady. She was basically tarnishing my image and accusing me of being a husband snatcher. I would usually blink at these types of accusations and let them go because I find them to be unnecessary distractions. However, the matter has gotten to the point where our bosses have even gotten wind of it. The issue has graduated from personal matters to she accusing me of sabotaging her at work. I am due for promotion, and I feel her ravings and rantings might cause me to lose out if I don't nip this in the bud. Can I sue her for defamation? How can the law help me? All right. So, what do we say to these things?
So clearly, this will fall within the domain of what we call torts, civil wrongs, and specifically the tort of defamation.
Okay.
And to succeed in such an action, you might need a number of things, particularly first to prove with evidence that there's been a publication of defamatory statements or comments about you, and that the person you're bringing the action against is actually the one who published those defamatory comments or material. So that's the hurdle that you will need to cross in establishing the tort of defamation, and the fact that that which was said in the publication reduced you in the eyes of right-thinking men. So that it was said such that in the eyes of right-thinking men, you will be reduced.
Okay.
And that is
your reputation.
Yes, and so that standard will lead to an injury of your reputation.
Okay.
But then to say that your reputation has been injured, you need to show that when I see this or I hear this, definitely I will think less of you in a certain way. So that's what I'll say briefly about this issue in relation to I don't know.
Yes. So it's laid out the law. So there should be publication, like I said. The information must be published. Publication means a third person must hear it.
Okay.
If it's just between the two of us, you can't say that's information.
Published.
A third party must hear it, and once a third person hears it, we can say that is publication. There should be sufficient identification of the person. That's why sometimes people use cartoons and they despise or they disguise the character in a certain way. So that's trying to conceal the identity of the person. But sometimes you and I know that is a particular person we are talking about. So sometimes that doesn't suffice. That you should be able to sufficiently identify, or I should sufficiently be able to identify that I'm the one being referred to.
Okay.
The statement made must be false. If the statement is true, then that's a defense for the other person, because the defense for it is truth or fair comment.
Okay.
And so it must be false.
Okay.
Also, like Clement said, there must be injury caused to you or your reputation. So in this case, was a thing published? Said he had recordings.
The audio recordings.
So people have heard it. That is publication. Do people know? Has he been sufficiently identified as the person in the audio? I think yes, because people, refer to the audio. People refer to the audio in relation to her. So she's been sufficiently identified. Whether the statement is true or not, that she has to tell. And from what she's saying, it's not true. So there she goes. Whether it's caused her injury, I'm sure obviously that there's been reputational matters. And she's even afraid that the reputational damage may cost her promotion at work. And so that is on all fours, I think, quite an interesting or a good case for a defamation action. We need to look at what defenses, are available to the other persons too. We talked about fair play, fair comment, truth, privilege, etc. We don't know what they have. We don't know what it is. So I think her lawyer will advise her appropriately on what to do. But generally, that is the framework for the matter she has said within in the context of the law.
Okay, super. Well, let's take a look at our legal trivia for today.
Legal trivia. Do you know a consent is of no effect if it is given by reason of a fundamental mistake of fact? This can be found in Section 14E of the Criminal Code, Act 60. Take note and do the needful. That will be all for our legal trivia today.
Welcome back. Now, this has been a question of law. The conversation has been very exciting, but I can promise you that the issues in Parliament are not ending anytime soon. Definitely, it's going to be, back and forth that's going to go on, and eventually, hopefully soon, we will rest this. But it has been a question of law. Thank you very much to my guests today, to Selma Donu and to Clement Kojo Akuapem for joining me on this show today. Thank you very much. Keep watching City TV. My name is David Kwekusechi.